Welcome. This is a pre-recorded module of the FSIS Preventing and Correcting Sexual Harassment in the Federal Workplace Training, presented by the Federal Employment Law Training Group. I'm Deb Hopkins, the Executive Director of the Federal Employment Law Training Group. Happy to talk to you today about one of the hot topics across the federal government, and that is sexual harassment in the federal workplace. And I'm talking specifically today to federal supervisors. There are a lot of questions, and there tends to be a lot of confusion about what constitutes sexual harassment. So for the next hour or so, we're going to talk about sex discrimination, sexual harassment, and really going to cover the bases and what exactly is considered sexual harassment and sex discrimination. As we like to do at the Federal Employment Law Training Group, we start with the law, because this lays the foundation and determines what is considered illegal under Title VII. So on slide 2 here, we've pulled direct language from Title VII for you to reference. It shall be an unlawful employment practice for an employer to fail or refuse to hire or discharge. Okay, so it's unlawful if you refuse to hire someone or if you discharge someone, that's another word for terminating, an individual, or if you otherwise discriminate against an individual with respect to the compensation, terms, conditions, or privileges of employment because of such an individual's sex. So if you take any kind of action, if you discriminate against an individual because of their sex, then that violates the law. It is illegal under Title VII. There are other protected categories as well, but today we're talking specifically about sex as a protected category under Title VII. Sexual harassment is a form of sex discrimination under Title VII, and here's what the EEOC says about it. Unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature constitutes sexual harassment when submission to or rejection of this conduct explicitly or implicitly affects an individual's employment, unreasonably interferes with an individual's work performance, or creates an intimidating, hostile, or offensive work environment. Now, that's a lot of words in one sentence here. I just want to pull out a few of the key words for you to understand as a federal manager. First of all, unwelcome sexual advances, requests for sexual favors, or other conduct. We'll talk a lot more in detail as we go on today about what type of conduct is considered to be sexual harassment under Title VII. So it's unwelcome conduct when submission to or rejection of this conduct is going to affect the individual's employment. It can be explicit or implicit. So it doesn't have to be something as out there as, I'm your supervisor, you have to have sex with me, otherwise I'm not going to promote you. We don't see that happen very often. That would be pretty explicit. But if it implicitly affects the individual's employment, it can be found to be sexual harassment, which is sex discrimination. And if it unreasonably interferes with the individual's work performance, or if it creates an intimidating, hostile, or offensive work environment, it will rise to the level of sexual harassment, and you will be found to have engaged in sex discrimination, which violates Title VII. Okay, so we need to talk a little bit more about what the law says constitutes sexual harassment. So this just breaks down some of the things we talked about and pulled out of that language on the last slide. Sexual harassment occurs when submission to such conduct is either explicitly or implicitly a term or condition of employment, submission to or rejection of such conduct by an individual is used as the basis for employment decisions affecting such individual. So, for example, if the individual submits to the conduct that you've requested, and as a result, you give the individual a promotion, that constitutes sexual harassment, or it can constitute sexual harassment. If the individual rejects the advances and as a result doesn't get a promotion or gets reassigned somewhere less desirable, that can constitute sexual harassment. So it doesn't necessarily have to be a negative employment action. If the individual submits to it and their professional career excels as a result, it doesn't get you off the hook as a supervisor. The final hash mark here, the conduct has the purpose or effect of unreasonably interfering with the individual's work performance or creating an intimidating, hostile, or offensive working environment. And we will talk in detail about all of those things as we go through the session today. So the first question we need to ask is, who can harass? Who is the person who can engage in harassment of another individual based on sex? So the employer, in this case the agency, needs to address harassment, no matter who's perpetrating it. Today I'm talking specifically to federal supervisors. And most of the time in the federal government, in sexual harassment cases, we do see that the supervisor is the person who is alleged to have harassed a subordinate employee. That's not always the case. Sometimes we've seen coworker harassment, even harassment of a subordinate against the supervisor, a former employee, a non-employee, including perhaps a customer or a contractor. So all of these individuals can harass, but we're talking specifically today about supervisors. So is the agency liable for sexual harassment when a supervisor engages in harassing behavior against an employee based on that employee's sex? In order to establish a claim of sexual harassment, the employee has to show he or she was subjected to unwelcome conduct that was sexual in nature and for which a basis exists to impute liability to the employer. Lots of fancy legal words here. We're going to talk in plain English about what that exactly means. So on slide 7, we're breaking down the elements of sexual harassment. So all 4 of these elements are required in order for someone to prove that they were sexually harassed in the federal workplace. First of all, we have to look at the conduct. What kind of behavior is considered to be harassing behavior? Is it physical? Is it verbal? Are we talking about threats? Are we talking about assault? Let's look at the conduct to see what exactly is going on against the purported victim. The next thing we'll look at is the nexus. That's another legal word. It just means, is it related? Did the harasser perpetrate the conduct because of the employee's sex? We've seen cases where supervisors pick on employees for a number of reasons, but in order for it to be considered sexual harassment as sex discrimination under Title VII, the conduct has to occur because of the employee's sex. Number 3, is the conduct unwelcome? Was it unwelcome to the victim, or did the victim willingly engage in the conduct with the alleged harasser? And then finally, liability. Who's responsible? Is the employer, in this case the agency, legally liable? So there are a couple of things we look at. Was there a tangible employment action? And we'll talk specifically about what tangible employment actions are, but just in general, it's when an employment action is taken against an individual because the individual refuses to engage in a sexual relationship with the supervisor, or the hostile work environment where there's not necessarily an employment action. There's not a removal, there's not a reassignment, there's not a demotion or termination, but the conduct was so severe or pervasive that it made the workplace a really uncomfortable place to be. And it altered the terms and conditions of employment. That's a legal term that the EEOC will use in looking at the situation. So these are the elements of sexual harassment. We are going to spend the next few minutes going through these in detail so you can have a complete understanding. What exactly is sexual harassment? How will it be looked at from a legal perspective? So the first element, the nature of the conduct. What does it look like? Sexual harassment can take on many forms. I've got a list here. This is not a complete list. We could probably talk and come up with another 50 or 100 examples in the next few minutes alone. But sometimes this is what sexual harassment looks like. Physical conduct or contact. Things like groping, bodies brushing against each other, hugs, kisses, those types of things. Verbal statements. Remember, the statements have to be motivated by the victim's sex in order to be considered conduct that can feed into the sexual harassment. Offensive pictures or symbols. We see this a lot of times with pornography in the workplace. Symbols could be things like drawings If somebody in a meeting is drawing a picture on a notepad and an employee who's sitting next to that person sees it, well, wait a minute, that could be considered conduct that's offensive and based on sex. Changes to duties or changes to the work environment. Monitoring the employee's conduct or performance. If you have a supervisor who has approached an employee and has wanted to start a sexual relationship and the employee has said no, all of a sudden the supervisor monitors everything the employee does, that could be conduct that constitutes sexual harassment. Exposure to harm or a combination of the above, or as I said earlier, we can go outside of this list certainly and come up with additional examples. But for the purposes of today, I think you have a general idea of the types of things we look at in analyzing, is this sexual harassment? Now, a couple things I want to point out. We're not just talking about males harassing females. Same-sex harassment, all the way back in 1998, the Supreme Court ruled that the harasser and the victim don't have to be of the opposite sex. So in this case, on Cal, this case involved a bunch of guys working out on an oil rig in the ocean somewhere. And the employee in this case was a male. And he was subjected to sex-related humiliating actions by male supervisors, including assault and threats to rape. Now, according to the facts of this case, the guys who were making fun of the complainant in this case, they were straight, but they were still found to have engaged in same-sex harassment. Because the court found here harassment need not be motivated by sexual desire. So the conduct that they were engaging in, the actions, the threats, the physical intimidation wasn't motivated by a sexual desire, but it was motivated by the victim's sex because he did not comply with what the guys on the oil rig thought other guys on the oil rig should behave like, should act like. So same-sex harassment is protected under Title VII. LGBT harassment. There was an executive order that came out a few years ago, signed by President Obama, that said federal agencies cannot discriminate against individuals based on sexual orientation. And in a lot of EEOC cases, the EEOC has found discrimination against lesbian, gay, bisexual, and transgender individuals based on sex stereotypes, unlawful discrimination under Title VII. So we've got to really expand our view here, if not a male supervisor harassing a female employee. On slide 11, continuing on the topic of LGBT harassment specifically, back in 2012, the EEOC held that discrimination against an individual because the person is transgender. Now, sometimes you might hear this called gender identity discrimination. That is discrimination because of sex and therefore is prohibited under Title VII. It's against the law. You cannot discriminate against somebody because that individual is transgender. If you discriminate against that person, if you harass that person because of their transgender status, that violates Title VII. That is sex discrimination. In this particular case that I've got here on the screen, Macy versus Department of Justice, Mia Macy is a transgender female who was selected for a promotion at the Department of Justice and informed her supervisors that before starting her new position for which she had received the offer of promotion, she would be undergoing gender reassignment surgery and would be presenting as a female. And her supervisors were used to her presenting as a male in the workplace. Once they found out Mia Macy was undergoing gender reassignment surgery, they rescinded the job offer. They were found to have engaged in sex discrimination because Mia Macy was a transgender individual and that employment action was taken based on her sex. And when that decision came out in April 2012, it was pretty revolutionary. It was certainly something that we hadn't really seen before. There were a couple of other cases that occurred previous to 2012 where the EEOC took a similar stand, but the language that they used in that case was pretty strong, and the first we had seen where they explicitly said that transgender discrimination is sex discrimination under Title VII. Now, moving on to slide 12, this is something that occurred in July of 2015 where the EEOC took an even firmer stand where there was a complainant who claimed sexual orientation discrimination. Now, traditionally, sexual orientation was not considered a protected category. So if an individual felt discriminated against based on sexual orientation and would file a complaint, they wouldn't have a leg to stand on because sexual orientation discrimination was not covered as sex discrimination under Title VII. But in this case, and I'll just point out, the case is called Complainant. A couple of years ago, the EEOC started rescinding the name of the complainant in the cases, and they just use the word complainant. So if you're wondering why is it called complainant, a lot of the cases for about 2 years were given the name complainant. The EEOC has now gone to using pseudonyms for case names. So if there's any confusion, I just wanted to explain that's why this case is called the complainant case. Any cases from about 2013 to 2015 will have complainant as the name, and then the agency is the defendant in the case here. So the EEOC said sexual orientation discrimination is sex discrimination because it necessarily entails treating an employee less favorably because of the employee's sex. So the complainant stated a claim of sex discrimination. And we've seen this because gender discrimination has been found to be sex discrimination under Title VII. When an individual does not comply with traditional gender norms, that individual has been found to be the victim of sex discrimination. That goes all the way back to the 1970s. But sexual orientation has always been treated differently. And here the EEOC finally clarified on slide 13 what it means when it says sexual orientation is protected. For example, assume that an employer suspends a lesbian employee for displaying a photo of her female spouse on her desk, but does not suspend a male employee for displaying a photo of his female spouse on his desk. The lesbian employee in that example can allege that her employer took an adverse action against her that the employer would not have taken had she been male. Sexual orientation discrimination is also sex discrimination because it is associational discrimination on the basis of sex. That is, an employee alleging discrimination on the basis of sexual orientation is alleging that his or her employer took his or her sex into account by treating him or her differently for associating with a person of the same sex. Now, there's a lot of language in this decision, but it's really important language to talk about because the EEOC is saying you cannot discriminate against an employee based on their sex. If you harass an employee based on their sex and their sexual orientation, you are found to have violated Title VII. Important to know as a federal supervisor because the law has changed. On slide 15 here, there are 3 additional cases that are recent cases where the same holding, where the EEOC said sexual orientation discrimination is sex discrimination under Title VII. In the Army case, in the first bullet, there was a male nurse who worked in an Army hospital, and the hospital commander subjected the male to harassing behavior because of the male's sexual orientation. And he made comments like, gay men aren't fit to work in this workplace, things like that. That is sex discrimination based on sexual orientation. In the SSA case, this is interesting, a coworker made a number of comments about one of the fellow coworkers in the work unit about the coworker's sexual orientation, told everyone around the workplace that the coworker was gay, even passed around pictures of the complainant in the case in gay bars and things like that, and that was found to have created a hostile work environment, sex discrimination based on sexual orientation. And then finally, this Department of Treasury case, the supervisor made a number of homophobic comments about one of his employees, and the EEOC looked at that in September of 2015 and said, you know what, that's sex discrimination based on sexual orientation, illegal under Title VII. So that's something that changed a lot. So all the way up until July 2015, sexual orientation was not explicitly covered, but now it is. So you've got to keep that in mind as a federal supervisor. on slide 16, we've brought up a couple of cases here. And the case citations, you don't really need to know. What you need to know is what the court said. Sexual harassment which occurs off the work premises and after duty hours does not deprive the agency of the jurisdiction to investigate when the effect of the off-duty conduct is to create an intolerable influence in the employee's working conditions. What does this mean to you as a federal supervisor? It means you can be found to have sexually harassed an employee off-site. When you're not at work, when you're somewhere else, doesn't get you off the hook. These cases that I've given examples of, the first one, the Army case, there was a temporary lodging facility in Germany where a number of the agency employees were staying, and the complainant and the supervisor were staying in the same place, and the supervisor made sexual advances and harassed the victim in this case. Just because it didn't happen at their work building didn't get the supervisor off the hook. The supervisor was found liable for sexual harassment. In the other case here, the Air Force case, the victim was harassed at work but also after work. Her supervisor would call her at home and would follow her as she left the work building. So even though it occurred at work, it occurred after work as well. And when the EEOC was looking at that, it found that was enough to alter the conditions of the employee's work. She didn't want to come to work anymore because she felt unsafe because her supervisor was harassing her. It was sex harassment, and the supervisor was found to have engaged, and the agency was liable. So all of those things we talked about so far were considered under Element 1 conduct. So it certainly is male to female and female to male harassment, but it also includes same-sex harassment, LGBT harassment, and harassment based on sexual orientation and gender stereotyping. So a lot is covered under the title of sex, under sex discrimination in Title VII. Moving on to slide 17 here, the next element that we have to prove in order to show sexual harassment has occurred is that nexus between the conduct and the victim's sex. So the conduct must be due to the victim's sex. What does that look like? Well, sometimes it's explicit, sexual advances or propositioning. That's probably the easiest way to show this nexus requirement. There can be touching, hugging, kissing, of course, brushing past. Sometimes this happens in hallways or doorways where someone gets unnecessarily close to the victim as they brush past. Displaying sexually suggestive objects, pictures, or writings in the workplace. Look out, sometimes you can see emails, even something like an email joke, an off-color joke about sex being sent around. Comments including sexual jokes, describing sexual experiences, or asking about sexual experiences, those can all demonstrate that nexus between the conduct that occurred and the victim's sex. Okay, the third element was the conduct unwelcome. The complaining employee has to establish that the sexual conduct was unwelcome. So on slide 19, we're going to talk about a case that will explain what unwelcome actually looks like. Michelle Vinson was an employee of a bank, and she was discharged for excessive absences. She took sick leave for an indefinite period of time. It was something like September of that year, told her supervisor, I'm really sick, I need to go on leave. Didn't say when she would be back, and a couple of months later, I think around December, she was fired because of the excessive absences. So Michelle Vinson brought a Title VII action alleging she was constantly subjected to sexual harassment by Sidney Taylor, who was the vice president at the bank where she worked. So here's what happened. In general, Sidney Taylor would proposition Michelle Vinson, and she said no at first. But she ended up giving in to his sexual advances because she was afraid of losing her job. And over the course of time where they had the sexual affair, it was about 40 to 50 times she engaged in the conduct. Doesn't necessarily mean it was welcome, but she engaged in the conduct. Doesn't necessarily mean it was involuntary. We're not talking about a sexual assault here. So just because somebody engages in the conduct doesn't mean it's welcome. Unlike previous cases involving race, national origin, and religion, which are protected categories, in this case we're talking about now that voluntariness question came up. Just because somebody engages in the activity doesn't mean that it's voluntary. And the defense here that the bank came up with was that, hey, she said yes to him. It was voluntary. She participated willingly. It wasn't a sexual assault. He never forced her. So that was the defense that the bank came up with here. And it was the first time that this issue had gone up, so the Supreme Court took a look and said, the fact that the sex-related conduct was voluntary in the sense that she wasn't forced to participate against her will, that's not a defense to a sexual harassment suit brought under Title VII. The focus of any sexual harassment claim is that the alleged advances were unwelcome. Did she really want to engage in that behavior? So the Supreme Court said on slide 22 here, the correct inquiry is whether the respondent, by her conduct, indicated that the alleged sexual advances were unwelcome, not whether her actual participation in sexual intercourse was voluntary. So they drew the distinction here. It doesn't have to be a sexual assault to be considered unwelcome. So how do we know if the conduct is unwelcome? Here's what the EEOC will look at and the higher courts will look at. And here's what your agency investigator is going to look at when conducting an investigation on an allegation of sexual harassment. First of all, the reaction to the conduct at the time it occurred. Also regarding the complainant or the victim here, in this case, who, if anyone, was told about the conduct when it occurred. So let's say the employee at the agency gives in to the request of the supervisor to engage in a sexual relationship. Did that person tell anyone? Not just people at work, because most of the time the victim of sexual harassment, particularly a victim who feels she has to engage in the conduct or he has to engage in the conduct to keep his job, to keep her job, won't want to tell someone at work. Did they tell anyone else? It could be a spouse, it could be a friend, it could be a loved one. So the investigator will look at that. Any memorialization of the conduct. Did the person write about it in a journal? Did the person take notes on it? And then any anomalies in reporting the conduct. These are some of the factors to look at when considering, was this conduct unwelcome? In the case here that I brought up, there was a complainant who filed a sexual harassment claim and didn't report it, though, for 8 months after the conduct she said happened. And the conduct in this case was sexual jokes and sexual banter, discussions of a sexual nature, some dirty jokes told in the office. So she didn't report it for 8 months after it allegedly occurred. And in looking at this case, the EEOC said, well, you participated in the banter and you didn't report it for 8 months. You didn't give any indication that it was unwelcome. So therefore, you don't have a claim of sexual harassment based on sex here. A couple other examples in looking at whether or not the behavior is welcome. The fact that a sexual relationship was once consensual does not mean that later conduct is welcome. So let's say you have an employee who engages in a sexual relationship with a supervisor. Doesn't mean it has to be that way. The employee can end it at any time. In this case, Green versus the administrators of the Tulane Education Fund, the employee had engaged in a sexual relationship with a supervisor and then decided to end it. I believe she ended up going back to a prior boyfriend or something. The reason doesn't matter. What matters is she specifically and clearly ended it with the supervisor. Supervisor didn't like that, came back to the employee and tried to get things started again, and the employee said no. As a result, the supervisor started picking on the employee, not just picking on her, but harassing her, including things like searching her desk when she wasn't at the desk, requiring detailed medical information whenever she took sick leave, things that he did not do for other employees. So it was found that that behavior, although consensual initially, was unwelcome. Another example of unwelcome behavior, or the requirement to meet the unwelcome, Engaging in similar conduct may or may not indicate that the conduct was welcome, depending on the circumstances. So some things to look at here. Was the conduct similar in terms of the kind, the nature, and the degree? And who initiated the conduct? Was it the employee, or did they use it defensively? One of the times we see this is if there are a group of people telling off-color jokes. A lot of times an employee is not going to speak up or say, I'm offended. In fact, a lot of times when we get uncomfortable, we might even laugh at things that we don't think are funny. So just because an employee was there when the joke was told and didn't speak up and say, I feel like I'm being focused on or harassed because of my sex, doesn't necessarily mean that the conduct was welcome. So one more aspect here of the unwelcome require. In this case, it was an interesting workplace. In fact, if you're just bored on the metro ride home someday, I'd suggest that you read this case. I've never really heard of a federal workplace quite like this. It was a very touchy-feely place where in the morning, when everyone arrived to work, they hugged each other, they kissed on the cheek, a very unique and strange work environment. And there was a supervisor who hugged everyone, male and female employees, in a non-sexual manner. And looking at this particular case, male and female coworkers alike testified that they showed platonic verbal and physical affection toward the supervisor. The supervisor showed the same affection toward the employees, and that the complainant in this case, who alleged she was being harassed, engaged in a lot of the same behavior with the supervisor. She even visited his home and sent him a birthday card after she filed an EEO complaint against him. And here's how bad it got. I mean, it got to a point where the supervisor, when he was in the same room with the complainant, would grab his genitals in front of her, would shake his rear end in her direction, those types of things. But because this was the culture of the workplace, and because the complainant engaged in a lot of similar behaviors, the EEOC said it wasn't unwelcome for the supervisor to do it. Now, I will point out, the EEOC had an opinion on what a strange work environment this was, and they said it was not ideal, and they did not condone the type of culture in that environment. But regarding this specific complaint, it wasn't unwelcome. Therefore, there was no sexual harassment against the victim. All right, so we've talked a lot about what constitutes welcome and unwelcome behavior. The final element that we have to talk about is liability to the employer. The employer is the agency in this case. Is the agency liable when a supervisor engages in sexual harassment against an employee? There are two categories we'll talk about: tangible employment actions and hostile work environment. So there are two scenarios that can feed into what constitutes sexual harassment. First of all is a tangible employment action. And the employer is strictly liable, which means the agency is always liable for sexual harassment if the employee shows the other three elements that we talked about. Remember, the conduct, the nexus, and that it was unwelcome, and that the supervisor took a tangible employment action against the employee. The tangible employment action, we're going to talk about what those are. Things like hiring, firing, failing to promote, disciplining, reassigning with different responsibilities, causing a significant change in benefit. Why is the agency liable in that case? Because somewhere higher up in the agency, somebody has to sign off on this employment action. So we're not talking about something as simple as a supervisor moving an employee's workspace down a couple of spaces in the office. These are employment actions that significantly alter the terms and conditions of an employment within the federal government. If somebody is fired or not promoted or is disciplined, that could be a suspension, it could be a demotion. If they're reassigned with different responsibilities, these are tangible employment actions that require a higher level of review by the agency. So there's a Supreme Court case that set out a definition of who exactly is a supervisor for the purpose of a tangible employment action allegation of sex harassment. And the Supreme Court said an employee is a supervisor for purposes of vicarious liability. That's a legal term that means the agency is liable for the decision the supervisor makes. the tangible employment action. Under Title VII, if he or she is empowered by the employer to take the action against the victim. So the person's supervisor, if they sign off on that non-selection, that demotion, that termination, that's what's considered a supervisor. So sometimes it's not necessarily the individual in the chain of command. It could be a deciding official, for example. So it broadens out a little bit who exactly is a supervisor. Another couple of cases that we talk about today talk about hostile work environment. So tangible employment action, these are the things that alter the conditions of employment, usually on some kind of a label basis. Those things we talked about, like a promotion, a non-selection, a termination, some kind of discipline. Tangible employment action. The agency has to sign off on it, whatever it is. It doesn't necessarily have to be a tangible employment action, though, to be considered sex harassment. Hostile work environment is the other category of sexual harassment that we see. And we tend to see these more in the federal government than tangible employment actions, just because very rarely is there a case where a federal supervisor says to an employee, if you sleep with me, I'll give you a promotion. If you don't sleep with me, I'll fire you. It happens, but not very often. The hostile work environment, the analysis is a little bit different here, and we see these cases a lot more because they don't quite rise to that level, that threshold where a change in the status of employment occurs. However, the environment where the victim works is what changes, so that's what we look at here. An employer, in this case the agency, may be liable for harassment that did not include a tangible employment action where the harassing conduct was so severe or pervasive as to alter the terms or conditions of employment. We're not talking about a different pay grade here, but we're talking about action that was so bad that it changed the terms or conditions of employment. So there's a subjective and an objective element in looking at hostile work environment harassment, specifically what's severe or pervasive. First of all, the employee has to be offended by the conduct. If the employee is not offended, then they don't have a claim of sex harassment. But also, so that's the subjective element. The employee was offended by it. The second element is objective. Would a reasonable person find the conduct offensive? We all know there are some employees who are really incredibly sensitive, but most people wouldn't be offended by certain conduct. So would a reasonable person find the conduct offensive? So here's some fancy language from that case we talked about earlier, on call out on the oil rig. The Supreme Court said, objective, reasonable person standard. It considers the social context in which particular behavior occurs and is experienced by its target, which inevitably depends on a constellation of surrounding circumstances, expectations, and relationships, which are not fully captured by a simple recitation of the words used or the physical acts performed well. What in the world does that mean? We've got to look at context. The reasonable person standard, what is going on in the whole universe while this alleged conduct is going on. So the reasonable person standard takes into account the protected characteristics of the employee alleging harassment, the reasonable woman in the case of sex discrimination, or the reasonable man, the reasonable Hispanic male, etc. So depending on the protected category, you've got to look at the big picture. So EEOC's Office of Federal Operations uses this language a lot. It's important to know as a federal supervisor. EEOC regulations are not to be used as a general civility code. They forbid only behavior so objectively offensive as to alter the conditions of the victim's employment. Simple teasing, offhand comments, and isolated incidents, unless they're extremely serious, will not amount to discriminatory changes in employment terms and conditions. Now, that doesn't necessarily mean it's a good idea to pick on your employees. And I'm not suggesting you do, and I know your agency wouldn't suggest you do either. But we're talking about legal liability here. So isolated incidents and comments probably aren't going to meet that pervasive requirement. Pervasive Another way of looking at that is kind of how many times did this happen? Although in some cases once is enough, which is what severe means. How bad was it? A sexual assault probably only has to happen one time in order to be severe enough to alter the terms and conditions of employment. But as far as violating the law, simple teasing and offhand comments probably don't meet that standard of severe or pervasive. Now, in this case, another Supreme Court case, there was an individual who was assaulted because of gender and sexual innuendos were made, and the Supreme Court said that the standard here for severe or pervasive takes a middle path between making actionable any conduct that's just offensive and then requiring the conduct to cause a tangible psychological injury. It's somewhere in the middle. So whether an environment is hostile or abusive can be determined only by looking at the big picture, all the circumstances, the frequency of the conduct. Was it a dirty joke told only once, or did the supervisor make a habit of telling dirty jokes with sexual innuendo at every single meeting of the staff? Its severity. Was it physically threatening? Was it humiliating? Or was it just a mere offensive utterance? And did it unreasonably interfere with the employee's work performance? Now, if it's so bad in the workplace that the employee feels he's being discriminated against because of his sexual orientation, so much that he's calling out sick or he's taking leave so he doesn't have to come in and be subjected to it, now we're talking this might be pervasive enough to meet that requirement of hostile work environment harassment. Here are some things to consider in determining whether the conduct is severe or pervasive. Frequency, how many times did it happen? And then the duration, how long did it last? Was it, a series of meetings over the course of 5 years where the supervisor spoke negatively about individuals of a certain sex? Or was it a one-time thing that was 15 seconds and it never happened again? The relative positions of the perpetrator and the victim, the supervisor versus the coworker, is what we see a lot of times. But we also have to look at the vulnerability of the victim, looking at things like age, mental capacity. That all goes into play on the severe and pervasive requirement. Also, the makeup of the workforce. Is the victim the only female or the only male with sex harassment? Is the individual the only person who's openly gay? Is the individual the only transgender individual in the workplace? Those types of things. Other things to look at, the African-American example, the Muslim example, those are other protected categories. The same kind of analysis would apply, though. So we talked about in a tangible employment action, the agency has no defense. Somebody had to sign off on that decision not to promote the individual or that decision to reassign the individual over to Buffalo when she worked in San Francisco. As far as a hostile work environment, there is an affirmative defense available. What is an affirmative defense? That's fancy lawyer speak for a fact or a set of facts offered by a defendant, in this case the agency, which can mitigate or even defeat liability. Okay, Deb, well, that's more lawyer speak. It's basically a reason why the agency shouldn't be found liable for sexual harassment. And if the court accepts the agency's defense, then the agency's off the hook, even if it's proven that the defendant actually committed the alleged acts of sexual harassment. So the best way to talk about that is to go through some of the cases where the EEOC has found such. So as long as the employer didn't take a tangible employment action against the employee, the employer may avoid liability. Doesn't mean they always do. Through an affirmative defense established in Ellers and Farragher, we're about to talk about those two cases. Even if the employee shows she was subjected to severe or pervasive unwelcome sexual harassment. So the first case that we're going to talk about here regarding the affirmative defenses is Burlington Industries versus Ellers. And Ms. Ellers was a salesperson who worked for Burlington Industries, and she alleged she was subjected to constant sexual harassment by her supervisor. They were on a business trip together, and he invited her to a hotel lounge. She felt like she had to accept because he was her supervisor. She gave no encouragement to remarks he made. He talked about her breasts, He told her to loosen up. He warned her, I could make your life really hard or really easy at Burlington. She didn't say anything. She gave no encouragement, but she didn't tell him to stop. At some point, she was being interviewed for a promotion, and her supervisor expressed reservations about giving her the promotion because she wasn't loose enough. And that's the actual term that he used. He followed up his comment by reaching over and rubbing her knee. Now, she ended up getting the promotion, but he continued with the inappropriate comments and suggested she wear shorter skirts to make her job easier. She ended up quitting after a shorter amount of time because of the harassment. She never told anyone in authority about the harasser's conduct. She never told anyone what the supervisor was saying and doing, even though she knew that there was a policy against sexual harassment. So because she didn't speak up, the court found no liability. So even though the facts showed that all of this happened, Burlington Industries was found not liable for the actions of its supervisor because the victim never spoke up. Now, in the government, I think one of the things the federal government does very well is it makes clear the EEO complaint process, and the victims of alleged harassment don't ever have to go to the immediate supervisor. They can contact an EEO counselor and talk about it, aside from talking with the direct supervisor or with the person who allegedly conducts. So as far as publicity of the anti-harassment policies and the complaint process, the federal government does a great job. In this case, Farragher versus the city of Boca Raton, we see a different outcome when the policy isn't widely distributed. The petitioner here, Beth Ann Farragher, was a lifeguard who worked for the city government in Boca Raton. Her supervisor subjected her to repeated, uninvited, and offensive touching by making lewd remarks and offensive comments about women. They included telling someone who was being interviewed for a lifeguard position that female lifeguards were expected to have sex with male lifeguards. And the district court in this case found the city never disseminated its policy on sexual harassment, and they made no attempt to keep track of the supervisor's conduct. The policy never included any assurance that the harassing supervisors could be bypassed in registering complaints. So that means an individual who was being sexually harassed by her supervisor had nowhere to go to complain about it. There was no assurance that the victim could go elsewhere to complain. So really there was no recourse. So the city of Boca Raton was found liable. The employer was found liable for that hostile work environment harassment. So the comparison here, there was liability against Boca Raton in the case of Ms. Farragher because the city of Boca Raton had a policy, but it wasn't disseminated to the lifeguards. There was no provision to bypass immediate supervisors. The victim had nowhere to go, didn't know she could report it. In Burlington Industries, there was no liability because the employer had a policy, the employee was aware of the policy, and she never reported the harassment. So these are all things that the courts will look at in analyzing claims of sexual harassment. So at FSIS, you have a policy, and all of the employees at FSIS probably have a requirement to sign off that they understand the policy. So as far as knowledge and dissemination, hopefully there will never be a case of liability on the agency because the policy was not distributed. But in those cases where there's an affirmative defense, yes, this conduct happened, but we took care of it as the agency. Here's what your agency has to show: that the employer, the agency, exercised reasonable care to prevent and correct promptly any sexually harassing behavior. So as soon as they hear about it, they work on correcting it. And even in advance of that, they work on preventing it from ever occurring, perhaps with training, perhaps with providing those policies and requiring supervisors and employees to sign off that they agree to abide by the policy. The employer also has to show that the employee unreasonably failed to take advantage of the preventive or corrective opportunities provided by the employer or to avoid harm otherwise. So remember that case we talked about a few minutes ago where the individual never reported the conduct until 8 months later. Part of what the EEOC looked at was the fact that she took so long to report it, and then they also looked at the fact that she engaged in the behavior. So here's what the agency's duty is: to exercise reasonable care in talking about claims of sexual harassment, promptly investigating those claims. As soon as the agency learns about it, as soon as contact with the EEO counselor is made, the agency has to look to see if there's merit to open an investigation, taking any necessary interim actions to prevent any harassment from continuing. What does that mean? Let's say that you have alleged sexual harassment on you by your supervisor. You report it to the agency. Maybe the agency puts the supervisor in charge of another work group. Maybe the agency allows you to go on admin leave, not punishing the victim, but changing the scenario so you don't have to report to that supervisor while the investigation is ongoing. Taking prompt corrective action if there is harassment found, and then ensuring that the victim is made whole. That's according to the EEOC enforcement guidance. What does making the victim whole look like? Well, in a lot of cases, it's something like, for example, you have a victim of sexual harassment who ended up using all of her annual leave or all of his annual leave because he felt uncomfortable and didn't want to come into the workplace because of the harassing behavior. As a result of the investigation and the finding of sexual harassment, maybe the victim gets all of that annual leave back because he wouldn't have taken the leave if not for the sexual harassment. So those are the types of things we look at to ensure that the victim is made whole. All right, more on the affirmative defense side. The investigation that the agency does to look into sexual harassment has to be conducted immediately. It has to be prompt, thorough, and impartial. It needs to be timely. If a fact-finding investigation is necessary, it needs to be launched immediately. People forget things. So the longer we wait, the less clear it will be. And employees are entitled to this prompt, thorough, and impartial investigation of these claims. It also needs to be done in a way that makes clear that immediate and appropriate corrective action will be taken if the allegations are sustained. So the agency needs to let the employee know, if we find sexual harassment is occurring, we are going to take care of it right away. You will not be subjected to this any longer. So if there's corrective action, there's a finding of sexual harassment. The corrective action needs to be designed to stop the harassment from occurring any longer. It needs to include disciplinary measures that are proportional to the seriousness of the offense. It can't adversely affect the victim of the harassment. So, for example, a supervisor is found to have sexually harassed an employee. The agency can't reassign that employee to another work group that's less desirable or where she'll make less money, or across the globe where he doesn't want to go. You can't adversely affect the victim of harassment. And then also, corrective action needs to include actions to address harm, such as reinstatement. Let's say there was a non-selection because an individual didn't give in to his supervisor's sexual advances. Maybe he deserved to get the job otherwise. It could be a reinstatement if the individual's been terminated in a tangible employment action. Expungement of disciplinary records. Maybe somebody gets a reprimand or a suspension and it's directly motivated by the sexual harassment, the tangible employment action. A restoration of leave we already talked about. Other appropriate remedies, including an apology from the harasser. Sometimes that's a term of corrective action. And finally, as a regulation for preventing sexual harassment, the agency needs to take all steps necessary to prevent it from ever happening. You know, we live in a world where we're not going to make everybody follow all the rules all the time, but in general, training is a really great way to make sure everybody knows what the law is, what they can and cannot do. So publicizing the anti-harassment policy, making sure everybody knows it, has access to it, and I even suggest signing off on it is a great idea. Affirmatively raising the subject. You know, don't wait until something bad happens, but talk about these topics before you have a problem. Express strong disapproval, develop appropriate sanctions, Inform employees of their right to raise a complaint and how to raise the issue. Make sure they know the complaint process and the way to go about making contact with the EEO counselor, and then developing methods to sensitize everyone concerned. I think specifically with more timely issues such as harassment of transgender individuals and harassment based on sexual orientation, because those are the newest developments, it's really important to make supervisors and employees in the agencies aware that those can constitute sexual harassment. So sensitize everyone who's involved at the current issues and trends that we see occurring. So we've talked about a lot of information today regarding sexual harassment, and certainly we could spend days talking about the specifics related to tangible employment action and hostile work environment harassment. But hopefully by now you have a general idea of the elements that comprise a claim of sexual harassment and also where liability falls. This concludes the FSIS Preventing and Correcting Sexual Harassment in the Federal Workplace Training. For additional information or assistance on sexual harassment, please email the Civil Rights staff at askcrd@fsis.usda.gov.